Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, as the title suggests, we're going to be discussing I-601 waivers. Specifically, we're going to be discussing them in the context of dealing with what's called a qualifying relative. Basically, what are we talking about here? Well, first of all, an I-601 waiver, for those who aren't aware, there are listed legal grounds of inadmissibility to the United States. They're designated in the provisions of the Immigration and Nationality Act. And if a finding of inadmissibility has been made by a consular officer at a U.S. embassy or U.S. consulate outside the United States, then that finding oftentimes can only be remedied by use of an I-601 waiver. What do we mean here? Well, let's say there's a finding of a crime involving moral turpitude, for example, some species of forgery, because the individual applying for a visa, let's say it's a marriage visa to the United States, has a prior conviction for a minor forgery charge. In that set of circumstances, most likely the adjudicating officer is going to make a finding of a crime involving moral turpitude, and that individual can only be admitted to the United States after an I-601 waiver has been issued. One of the aspects or one of the components of being able to get an I-601 waiver issued is a showing that extreme hardship would befall a qualifying relative of the applicant in the United States. What are we talking about with respect to qualifying relatives? Well, first of all, qualifying relatives need to be either a United States citizen or lawful permanent resident in the United States, and they need to be an actual relative. They need to be a family member. Okay, spouses and parents, they're always going to be generally considered qualifying relatives. So if you've got a U.S. citizen spouse or a U.S. citizen parent, that you can show extreme hardship. And specifically with the extreme hardship, there's another video on this channel that goes into some more detail about the issues associated with that. We're simply talking about qualifying relatives in this video. But basically, if you've got your parent or spouse and they're a U.S. citizen and you can show that it would cause them an extreme hardship to not admit you into the United States as the inadmissible alien, then you're probably going to be able to deal with that. Children also can be considered qualifying relatives under certain circumstances involving the I-601 waiver. And where children exist, again, they've got to be a U.S. citizen child or lawful permanent resident child. And again, they have to be actually related to the applicant. You can't have sort of a tenuous relationship, non-familial relationship. But that being said, so this is something of a narrow scope of people. It's not just any old American citizen or any old lawful permanent resident. It needs to be a relative of the person who's applying for the I-601 waiver. Now, in most K-1 or marriage visa cases, it's going to be pretty easy to show that because, you've got a spouse involved who's an American citizen or presumably an American citizen or possibly a lawful permanent resident. But that being said, the waiver has to pertain to a qualifying relative, and it needs to show extreme hardship. And as explained in another video on this channel, extreme hardship can be something of a difficult threshold to overcome, but I'll leave that for that video to discuss in more detail.